name's Maurice Sunkin. I'm just here formally for the moment, but I'll come back later on. It's great to see so many of you, and those of you who are online, welcome. Can I just say that we're not expecting a fire alarm. So if you do hear a fire alarm, you have to get out. We've got the fire exits, I think here and over there. That's the formalities. I'm going to hand over now to the Dean of the Law School, who do the proper welcome.
Good evening, everyone. I hope you can hear me from the back. My name is Onyeka, Osuji. I'm the Dean of Essex Law School. I am delighted, and in fact, as a school, we are honored to be hosting the public law lecture today. I'm not a public lawyer, just so you know, but I do know a lot of public lawyers within the school. In our school, public law is one of the pillars of the school. We have 4 pillars of the school: human rights, public law, international law, and private and business law. We have a number of colleagues who are actively involved in public law research and education. A good number of them are professors, reader, senior lecturers, and lecturers. It is a small community of scholars, and I do know the amount of work they do. So we are delighted, really, to have everyone here. So a warm welcome, those of you from outside, staff and students of the University of Essex who are here, as well as those of you online listening to and watching what is going on. Again, from a distance, I know about public law lecture. I do know that it is a very prestigious lecture series. So for us to host the lecture today, challenging times for the UK higher education sector, I have to mention that. It is a big thing, and that is why we are grateful to Thomson Reuters, the sponsors of the lecture, for sponsoring the lecture today. We're also grateful for the publishers of public law for supporting the event. We have the general editors of public law here with us, Aileen and Roger. Thank you so much for being here. We are deeply grateful for your presence. And I've talked about this is an honor, but it is really an honor to have Alison Young here as the lecturer for today's events. If you don't know about Alison, just put down the name. You can see that it is not just an outstanding researcher, but she is also a highly impactful scholar in policy and in scholarship. So I just want to say a warm welcome. In our school, Essex Law School, we thrive on a community of scholars. We thrive on excellence. We thrive on inclusivity, internationalization, comparative approach to whatever we do, whether in our research, in our education. That is what we are. And public law in the school is a major part of what we do. So I don't want to waste your time, but I hope it all goes well. I'm sure it will go well. I know who is going to speak in a minute. So thank you everyone for being here. And we are going to have a good evening. Thank you.
Thank you. Can everyone hear me? Yes, okay. So I'm Aileen McHarg. I'm one of the joint general editors of public law. And on behalf of my co-editor, Roger Masterman, who's sitting right there, and the editorial committee of public law, I want to extend my welcome to you as well. Public law, I'm going to puff ourselves here, but I think I'm allowed. Public law is the UK's leading journal in the field, and we are approaching our 70th birthday next year, so we're a very well-established journal as well. The tradition of holding an annual lecture is a little bit more recent. Maurice and I were trying to work out earlier exactly when it started. It started under his editorship. He preceded Roger and myself as general editor. But the precise date at which it started has become lost in the mist of time. But we think sometime in the early 2010s. It fell into abeyance for a short period, but when Roger and I took over, we decided we wanted to revive this tradition of having an annual lecture. And we held the first in the revived series this time last year at Durham University. And if you're interested, you can read last year's lecture, which was by Professor Meg Russell on the topic, should we be worried about the decline of parliamentary scrutiny? You can read that in the January 2025 issue of the journal. We are also very grateful to our publisher for once again supporting this event, and to Essex Law School for very generously hosting it. And we hope and we expect that in due course, this year's lecture will also appear in the journal in print form. As Onyeka just said, we do have another very distinguished lecturer this year. Alison Young spent most of her career at Oxford University, both as a student and as an academic. She then moved to Cambridge University in 2017 to take up the Sir David Williams Chair in Public Law, and she's also a fellow of Robinson College in Cambridge. Alison's research interests span all aspects of public law. Some of you may know her as the current person in charge of Turpin and Tonkin's British government and the Constitution. So she covers the entire span of public law in that context. But she has written very many different things, including 3 monographs, the most recent of which was the very prescient Unchecked Power, published in 2023, which warned about the risks of the rise of populism, risks that we are obviously seeing play out across the Atlantic at the moment. Amongst Alison's many achievements and many marks of esteem, she is a former advisor to the House of Lords Constitution Committee, and last year she was appointed to the Law Commission for England and Wales, serving as their Commissioner for Public Law and the Law of Wales. Now, in that capacity, Alison has extended her expertise even further. She now knows more than probably anybody in this room about a whole range of fascinating topics, including the subject of new funerary methods, which Alison never loses an opportunity to talk about, but not this evening. This evening, she is not sadly going to be talking about that. Instead, she's going to tell us why, in her opinion, Parliament is not sovereign, and it's a good thing too. Okay, over to you, Alison. Thank you very much.
Thank you very much, everyone, for those wonderful introductions. I'd like to thank both Aileen and Roger for inviting me to give this lecture. I'd also like to thank the University of Essex, especially Professor Maurice Sunkin, who has been a big influence on my academic career and has also been very instrumental in organising and hosting things today. It's been a real pleasure for me to come back to the University of Essex. I've been here a few times, and sitting in the audience is actually one of my former students. So Ebba had to suffer tutorials in constitutional law and administrative law, and is still alive to tell the tale. So hopefully, despite my expertise in new funerary methods, I will not need to deploy any of them going forward, because you'll all be alive and happy at the end of this lecture. So the public law lecture was revived last year, as we know, in which Professor Meg Russell gave an outstanding lecture at the University of Durham. And she was looking at the title, Should We Be Worried About the Decline of Parliamentary Scrutiny? Now, it is as difficult as me to follow in her footsteps by giving this lecture as it is to disagree with her conclusion. We both think we should be worried, and we both think there's a time now to think very carefully about how far Parliament actually does really scrutinise legislation, particularly thinking about things like placeholder clauses, skeleton legislation, and last-minute amendments to government bills, which I'm sure Roger's now spending a large amount of time in his role as legal advisor to the Constitution Committee, keeping an eye on for all of us. But for me, Professor Russell's lecture did not just raise questions about the state of our democracy. It also made me think about, what about Parliament? We spend our entire time saying that there's one key principle of the UK Constitution that I'm sure every single one of you can tell me right now, and that is the Westminster Parliament, or more accurately, the King in Parliament is sovereign. You're taught this over and over again in constitutional law, and we're told we're very different. We don't have a codified constitution. We don't have legal limits on the powers of the Westminster Parliament, and the Supreme Court can't strike down legislation because it's contrary to constitutional principles. In fact, there's only one limit on what Parliament can do, and that's it can't legally bind the successors. And this is kind of almost taught as a bit of a mantra. And we all know that Parliament, if it wants to, can just do whatever it likes. So if it wants to change constitutional rules, it can. It can enact the Fixed Term Parliament Act, give us a fixed term Parliament, and then later on decide, actually, let's enact the Dissolution and calling the Parliament Act 2022 instead, and go back to a maximum term rather than a fixed term. Not a problem. So given all those factors, why did I think it was a good idea to say Parliament is not sovereign, and it's a good thing too? So hopefully on the next slide, I'm going to set out a few kind of preambles. So first thing, if you come here thinking Alison's finally recanted, she's become Trevor Allen, she's now a legal constitutionalist, I'm sorry, I'm going to disappoint you. So I'm not going to tell you that this is what I think that laws should limit in some way. Second, though I do think there are problems with democratic decline and populism around the globe, I'm not going to tell you that I think now is the time to move to a system, because without that, in some way, shape or form, we won't defeat populism. I'm concerned about issues of populism and democratic decline. I'm just not convinced that moving to a constitution with legally enforced limits is either necessary or sufficient to tackle those problems. If you want to know why? Well, go look at the US, and I'll leave it there. Otherwise, I might get into trouble. You'll also be glad to know that I didn't accidentally sort of, put not in there by mistake. I'm a bit tired at the moment, we're quite busy, but that's okay. And nor am I trying to be cheeky and say, you all thought I meant Westminster Parliament. Haha, no, I didn't. I meant the Scottish Parliament, or the Northern Ireland Assembly, or the Senedd Cymru. I'm not doing that either. So what am I going to argue? Well, hopefully in the next slide, so Rebecca is ably helping me. The one I want to look at is a distinction that I think we often blur and ignore. And it's a distinction that I want to draw between parliamentary sovereignty and parliamentary legislative supremacy. And what I want you to do, hopefully, in this lecture, is to convince you of one key thing. So I'm going to throw these on the floor with me. What I want to hopefully show you is that I want to argue that although Parliament is not sovereign, it does have parliamentary legislative supremacy. And in order to do this, what I want to do is three things, which I've put on the next slide for you. So what I want to do first is I want to think about why is it some people think Parliament is not sovereign. And I don't want to just give you these arguments for the sake of it, but I want to do so in order to help illustrate this distinction I want to draw between sovereignty and legislative supremacy. Then I want to put why I think Parliament is not sovereign, but should have legislative supremacy. And finally, I want to try and persuade you why I think this is a good thing. So hopefully on the next slide, here are some of the arguments I want to go through in the first section when thinking about why is it some people think Parliament is not sovereign. And I've kind of split them into a reality check, what's going on internationally, and when we're trying to think about aspects of constitutional principles. So what do I mean by a reality check? Hopefully that's the next slide. There we go. So there are different aspects of things that put limits on what Parliament can actually do. So even Dicey himself recognised that Parliament can do everything that is not naturally impossible. So if Parliament decided, wouldn't it be a great idea to deny the existence of gravity and come up with the Anti-Gravity Act 2025? Go ahead, it would be a great piece of legislation. But if I drop my pen, it's still going to fall on the floor. You're not actually going to stop gravity from having an effect. But if you want to enact legislation that says it's unlawful to teach the theories of gravity and imprison those who teach it, that will have lawful effect. What I'm trying to explain here by giving you this example is this idea of what we mean by sovereignty and what we mean by legislative supremacy. When you're talking about these reality checks, it's an aspect of sovereignty. We're thinking about other things that Parliament can't do because in some way it's just not omnipotent. When we're talking about the legislation, we're thinking about legislative supremacy. If you want to go away and enact this piece of law, then someone will go away and enforce it. It will be valid law. Might be a bit useless. Well done, you've defied gravity. It's not actually going to achieve anything. But as far as the legal system is concerned, that will still have legal force. So I wanted to mention this to give you an idea of some element of what I'm trying to get at in this distinction between sovereignty and legislative supremacy. Another aspect that comes from my reality check is this idea of a limit that is placed on what Parliament can actually achieve in practice. So this is when we're thinking about aspects of civil disobedience. So even Dicey recognised that there are what he called internal and external limits on Parliament. And these external limits are these elements, is that not picking up? Sorry. Is that better? That's okay. There's always a technical hitch somewhere when there's normally me that does something. I tend to drop things or press the clicker too many times and you end up with things going wrong. But hopefully you can all hear me now. Brilliant. Okay. So we were talking about this idea of other limits on Parliament and the external limits that Dicey mentions that can be put on Parliament. And this is when we're thinking about the fact that Parliament has to make laws, but people are meant to obey them. What if they don't? Well, if you're kind of my age, you might remember things like the poll tax. And for those of you in the audience, go ask your parents and hopefully not grandparents. I don't think I'm quite there yet. And they might be able to give you an explanation of what happened during the poll tax. There was general civil disobedience against it. There were people who were willing to go to jail for not paying it. And eventually there's a policy reversal. Now, I'm not trying to say that civil disobedience works every time. What I want to try and get to your attention to is the fact that public opinion can limit what Parliament does. Parliament, members of Parliament and House of Commons are elected. They need to be re-elected. So they need to be aware of public opinion. You're not going to do very well if you keep passing unpopular laws. Hopefully you'll be re-elected, another government will come in that's more popular. So this is placing external limits on what MPs can do. But Dicey coupled this with what he called internal limits. So parliamentarians themselves exercise their powers in line with their characters. So for Dicey, that included things like moral values, might be different from the moral values that people have in society now. MPs might have values that are different. Societies are very pluralistic, but MPs are still going to have some values and characters that will influence how they act. For Dicey, he thought there should be a balance between these external and internal limits. What we're getting at when we're thinking about here is another element of how we try and distinguish between sovereignty and legislative supremacy. So when we're thinking about this idea of limits that get put on the power of Parliament in this sense, by the people, by the electorate, we're thinking about it in a political sense. Politics plus limits on what Parliament can do. When we're talking about legislative supremacy, we're thinking about it in the legal sense. We're thinking about a product that is made by Parliament, a law that is enacted. Is this validly enacted? Will this have force in the courts? Will this be something that is upheld? Dicey said that in the political sense, the electors are part of and the predominant part of the politically sovereign power. But that's not something that will be recognised by the courts. The courts are not going to go away and say, oh, this is what the people want, so this is clearly what a law is. They might be taking that into account when interpreting law, but they're not going to use that as a source of law. So we have this other element of the legal and political distinction that tries to help us think about the difference between this element of a reality check. We have the real world, we have civil disobedience, we have the conscience of MPs. They put different limits on, but they're different in nature, and they help to draw out this distinction between sovereignty and legislative supremacy. So what about the next slide? What about the rest of the world? Now, I'm not talking about absolutely everybody here. I don't have time. So what I'm going to focus on instead are those two institutions that we see as sort of, they're really sort of transnational rather than international, but they're seen as the institutions that have caused problems for parliamentary sovereignty or not in some way, shape, or form. So I want to think about the restrictions that come from the European Convention on Human Rights and the restrictions that came from the EU when the UK was a member of the European Union, and which we now find coming through the aspects of rights under the withdrawal agreement, most notably, particularly with regard to cases that have looked at this, the Northern Ireland Protocol and the Windsor Framework. So I'm going to look at the ECHR first, mostly because it's nice to start with something that's slightly easier. So when we're looking at the ECHR, what I want to think about is not thinking about the Human Rights Act, but I want to think about Article 46 of the European Convention of Human Rights. And this sets out that the high contracting parties undertake to abide by the final judgment of the courts in any case to which they are parties. So here you have an obligation in international law that says that the UK courts are bound to follow decisions of the European Court of Human Rights that are addressed to the United Kingdom. Now, this seemed to give rise to a form of conundrum. How can the UK Parliament be sovereign if it also has to abide by the judgments of another international organisation? Is that undermining its sovereignty in some ways? And one of the answers you normally get to this conundrum is to say, well, it depends on whether you're talking about international law or domestic law. So you often get told it is bound in international law, but it's not necessarily bound in domestic law. These are different things. They're dealing with different angles. And what I want to think about is to try and unpack that a little. I'm not necessarily going to try and persuade you that this is the right or the wrong way of thinking about it in these terms, but it gives us another understanding of this distinction between sovereignty and legislative supremacy. Because what it's getting us to think about is, what is our focus? Sometimes when we're talking about sovereignty, we're really talking about, are you a sovereign nation? So when we talk about the ability of the UK to enter into and withdraw from treaties, so therefore it's okay, it's not really harmed the UK sovereignty. It decided to join the European Convention of Human Rights. The UK can decide if it wishes to leave the European Convention of Human Rights. So its sovereignty is retained. It can decide whether it leaves or whether it enters. So we're thinking about it in terms of an international perspective. We often see it as an element of solving the conundrum of whether Parliament is sovereign, but really what we're talking about is the UK a sovereign nation? And sovereignty tends to think about things in those terms. Does that mean when I think about international law angles that there's no real role for legislative supremacy? Well, not really, because you then have the issue of what would arise if the UK decided to enact legislation without withdrawing from a treaty that says it doesn't have to follow provisions of the treaty. Now, given I'm duty bound as a law commissioner not to say things that are too controversial, I'm going to move on to thinking about that question by looking at it from some cases that we do have where this issue arose with regard to the European Union. This way, I can refer to cases and won't get into trouble for saying things I'm not necessarily supposed to say. What I want us to think about here when we're thinking about the UK's membership of the EU is the cases that arose when the UK was part of the European Union. Now, as I'm sure you all know, the EU is a different kind of institution. It's not like the European Convention of Human Rights. Provisions of EU law have direct effect. This means you can rely on them in domestic courts without any form of further implementation. Also, these have primacy. So if you have a conflict between a directly effective EU law and national law, EU law should prevail. And this should be the case even if the domestic law is in legislation. I don't want to spend too long thinking about elements of where we are now. I'll come to that later because I want to discuss the Alistair case later on in the lecture. But I want us to draw on what we do know from what happened when the UK was a member of the EU. And we know from cases like Factor Tame that you could have an injunction granted to suspend the operation of primary legislation. We also know from Benkebush that an Act of Parliament can be disapplied in order to allow an individual in that case to bring claims under EU law against her employer, which she wouldn't have otherwise been able to bring because there was immunity under an Act of Parliament. So we know that there is this element of recognising that in some cases, EU law can prevail even over Acts of Parliament. But what is this a question that's actually about? Because often we're told this is a question about sovereignty. I don't think this has got anything to do with sovereignty. I think this has got everything to do with legislative supremacy. In particular, it's asking us to think about what type of legislative supremacy does Parliament actually enjoy? Does it have a conception of legislative supremacy that allows it to bind its successors? Or does it have a conception in the same way that Dicey would argue that it can't bind its successors? So I do have a colleague of mine who used to tell me frequently that Factor Tame killed sovereignty. And well, maybe it killed legislative supremacy, but it definitely didn't kill sovereignty. And it's kind of unpacking this statement that kind of helps me think about this distinction between sovereignty and legislative supremacy. Because you have to think about, if you are binding in some sense, where did this come from? We're not saying something can bind Parliament. We're saying, can Parliament bind its successors? Parliament is deciding whether it's a Parliament that can bind its successors or whether it can't. So if there were limits in some way through the European Communities Act, with Parliament to bind its successors through a piece of legislation that tried to restrict what a future Parliament could do, I wouldn't see that as putting the UK in the same situation as, say, the US, where you have a constitution, where you can go to a court and use provisions of the constitution to strike down legislation. I would see that as meaning, well, maybe then the Westminster Parliament is like the Scottish Parliament, the Northern Ireland Assembly and the Senath Cymru. Not fully, because it's a different body that's enacting the legislation that's limiting powers, but it's legislation that's putting the limit, not some form of constitutional document that's similar. So in order to unpack that a little bit further, I want you to imagine we have the HRA 2025, okay? It's a new piece of legislation I've just invented. It's completely fictional in case anyone is getting worried. So in this hypothetical HRA 2025, I want you to imagine that this says that any law restricting convention rights has to have a 2/3 majority, okay? Then some distant future in 2030, Parliament decides it wants to enact an Act of Parliament saying that it is unlawful to express an opinion that criticises the government. So all hypothetical scenarios. You've all read Dicey. You all know how Dicey would look at that and say, well, that's very interesting. But when you enact a later piece of legislation in 2030, if you have not used the 2/3 majority in that piece of legislation, you have impliedly repealed not just the fact that you're supposed to protect convention rights, but also the fact that you need a 2/3 majority to remove or damage or undermine convention rights. That's one answer to the conundrum. Another answer would be to say, well, maybe we have changed. Maybe this would move us to what we call a manner and form theory. Maybe the fact that you've got this 2/3 majority means the courts would look at this and say, we didn't have the 2/3 majority here, so therefore this can't be legislation. Who's telling them this? Parliament, in my hypothetical 2025 Act. It is Parliament that is saying to the courts, we must have 2/3 majority here. So if that works, then couldn't you argue, well, then that's Parliament is still sovereign. It's just shifted what we mean by legislative supremacy, such that now it can bind its successors. In fact, in some ways, you could say it's even more sovereign, because beforehand, you couldn't bind your successors. Now you can. You have even more power than you had before. Well done, Parliament. So it's just getting you to think about this understanding of where this comes from. Okay, so I might not have convinced you so far. So let's move on to my third principle, which is looking at this idea of constitutional principles. Now, in case you're wondering, anyone marking exams or writing exams will realize that often when you're trying to write constitutional statutes, you accidentally write constitutional statute. So this is my example of a constitutional statute for you, in case you need something interesting to look at the moment. So there you go. It's one that's quite near to the MOJ, so it's easy to kind of get a picture of that one. So it might seem odd to be talking about constitutional principles in the UK because, yes, as I constantly tell you, we have dicey, we don't have a constitution that goes away and limits things in this way. But we do have constitutional statutes, so no one's quite sure what they are or how they work. And we do have some who argue that we have fundamental principles of the common law. And again, there's lots of disputes as to what they might mean, how you find them, and what impact they have. So I want us to again unpack this to see what this tells us about our understanding between sovereignty and legislative supremacy. So if we think about constitutional statutes, where do constitutional statutes come from? Good question. If you ask that legally, then we'll tell you, oh, it was this judgment of Lord Justice Laws in a case called Thoburn, in which Lord Justice Laws told us that there were such things as constitutional statutes. We know that there are such things as constitutional statutes because of what happened in Factortame, when somehow there's a conflict and EU law won that particular conflict. How was this allowed to happen? Well, that's because there are such things as constitutional statutes, said Lord Justice Laws. What about them? Well, they're different from ordinary statutes because they can't be impliedly repealed and other ones can. I think, okay. And Lord Justice Laws went on to say, well, specific words of express repeal are needed to demonstrate the intention of Parliament to override a constitutional statute. And we know from cases like HS2 that there can be almost like a hierarchy between different constitutional statutes and different constitutional principles. What happens if a constitutional statute tries to override an earlier constitutional statute? What do we do in that situation? Do we still say it can't be impliedly repealed, or does something else work? And the answer is, we're not necessarily sure we know at the moment, but it's always very interesting to have a think and think about how this might arise. Okay, so what I want us to think about is, so if there is this element of a limit, where is this limit coming from? Because hopefully you can see now, this limit is not coming from legislation. This limit is coming from a court judgment telling you there's such a thing as a constitutional statute. And because there is such a thing as a constitutional statute, this means that it can't be impliedly repealed. In fact, it's a bit of a revelation, I think, to Parliament. There's a what now? we did what? Oh, thank you. The only difference you can find with regard to constitutional statutes is there's some statutes of constitutional importance will be debated in the House of Commons as a full committee of the House rather than a bill committee. That's about it. There's nothing else necessarily in there that will make you realise the difference between a constitutional statute and an ordinary statute. So if there's a limit appearing here, it's coming from the common law, not necessarily from Parliament. You can see this even more when you start thinking about constitutional principles. And to explain this, I'm going to have to use the work of Trevor Allen, who gave his account of the different balances of different principles of the Constitution, thinking in particular about the rule of law and parliamentary sovereignty. And for Trevor Allen, it's the rule of law, not parliamentary sovereignty, that is the most fundamental principle of the Constitution. Now, Trevor Allen's theory does not say that whenever there is automatically a conflict between the rule of law and sovereignty, so a piece of legislation, the rule of law will always win out. It might do, it might not. It's going to depend on a lot of contextual factors, and a lot of the time it's very difficult to know precisely what would influence it. But there is the possibility that in a particular situation, the rule of law might have been breached to such an extent that the courts really don't have a choice under Trevor Allen's theory than to say the rule of law should prevail here, and this should be used to limit a particular piece of legislation. Again, where is this coming from? Well, it'll be fundamental principles of the common law influenced by the rule of law that will A, place the limit on the legislation, and B, tell you that there is a limit on the legislation. So it's not just that it's the courts that are telling you what these principles might be, either through recognizing something as a constitutional statute or from the drawing on fundamental principles of the common law, but it's also the courts that are telling you
what this limit is and how it applies in certain circumstances. And for me, that element of setting out what those limits are is part of sovereignty, not part of legislative supremacy. So that element of thinking about what are these rules, what is the limit on Parliament's lawmaking power, are there things it can and can't do, what do we mean by legislative supremacy, how does that work in certain circumstances, are there exceptions, are questions that are more to do with understanding, is Parliament sovereign? There is an element of legislative supremacy built into this, so we can see this because some of the consequences are Parliament might not have legislative supremacy. Parliament might be able to bind its successors. Parliament might be able to enact legislation in constitutional form that is different from ordinary legislation. But what I want to draw out of this is another element of what we mean by sovereignty as opposed to legislative supremacy. It's this element of asking these fundamental questions. Where does sovereignty come from? What's its nature? Are there limits on Parliament? What is Parliament? Because it's difficult to know in some senses where these actually come from. So I could, if I wanted to, as the Law Commissioner, write a lovely report on things like new funerary methods. The first report that's going to come up will be one on disabled children's social care. So that will be appearing before the end of this year. And in that report, we can make certain recommendations. Fantastic. The fact that the Law Commission has made those recommendations doesn't make it law. I mean, there are limits to the power of the Law Commission. We will make a recommendation. If that's going to become law, either the government, the Parliament are going to have to pick that up and do something about it. So the government might propose a piece of legislation that Parliament then enacts. The government might make delegated legislation to bring in aspects of the report, or it might be that the courts look at what we're doing and develop the common law in line with things in our report. So legislative supremacy, an understanding of what law is all the legal side of how it works, but there's sovereignty questions going on in the background that we have to answer so we can work out how do we work out why it is that a report of the Law Commission is not law. Where does this come from? So at the moment, you're probably looking at me thinking, this is a bit confusing. Please, can you give me some examples? So I will try. So if we move on to the second part of my lecture, I want to try and focus now on what I think. And what I think, as I've said, is that I think Westminster has parliamentary legislative supremacy, but I don't think it's sovereign. And hopefully, some of my discussion has helped you understand a little bit of what I might mean. But in order to explain it a little bit further, I want to draw on that discussion on the next slide, thank you, and think about factors that I think influence this distinction between sovereignty and legislative supremacy. So the first one I've drawn out there is this idea of sovereignty is an absolute concept, legislative supremacy is a relative concept. So absolute, we're thinking about, when we talked about our reality check, we're thinking about omnipotence. Is this something that you can't do? Because sovereignty tends to be seen as an all or nothing concept, which is why some people will tell me, you know, this case killed it, didn't just modify it or changed it. It's all or nothing. You either have it or you don't. Because sovereignty is seen in absolute terms. Legislative supremacy is not seen in absolute terms in the same way. It's a relative concept. It's about analysing your lawmaking power with regard to other elements that might claim to have lawmaking power or that might be recognised as law. So legislative supremacy tells us that the acts of the Westminster Parliament are the most important source of law in the United Kingdom. Sorry about that. But that's how the structure goes. And my apologies to the Senedd Cymru and the Scottish Parliament, other Northern Ireland Assembly, who don't have the same kind of lawmaking power. So this is kind of trying to get you to understand how you have this distinction between sovereignty and supremacy. A second factor that I'm hoping my examples helped you to draw out is this distinction between politics and law. And that comes from the inclusion of the word legislative supremacy. When I'm talking about legislative supremacy, I'm talking about relative lawmaking power, how you make laws, how you recognise law, what we see as a law in a particular society. So we said acts of the Westminster Parliament are the most important source of law in the UK. But when we're thinking about sovereignty, We can also be thinking about elements of reality check limits, but also political limits on Parliament. So one of the justifications you might have for why you think Parliament should have legislative supremacy is because of these political limits. That by having this political check, as you could see in Dice's terms, that people are the political sovereign. They are putting political limits on the lawmaking power of Parliament, therefore hopefully meaning that the laws that we have are fair, democratic and just. So it's drawing out this distinction between sovereignty and supremacy by looking at these different factors. The third element is drawing on our element of our perspective. Sovereignty can get examined not just from a domestic perspective, but also from a global perspective. We're thinking internationally. So we're trying to unpack this element of, is the country sovereign on the international stage, and what does that actually mean? Legislative supremacy tends to be domestic. We're thinking about the lawmaking power in a particular legal system, which is the highest form of land in that particular legal system. The fourth factor is the one that harder to explain without me having to delve into jurisprudence for which I apologize. But it's getting us to think about the ins and outs of this distinction that Hart draws between secondary rules and primary rules. And it's that question I kept saying, who is telling us that Parliament is sovereign? Often I think the answer to that is Dicey, but it can't just be Dicey is telling us that Parliament is sovereign. Dicey is not a source of law. So we have to think about what is it that lets us understand that Parliament is sovereign. And when we're thinking about this idea of secondary rules, we're thinking about something that I'm going to have to use French or German. So you're either going to have to, for the compétence de la compétence, or if you're going for German, competence. So it is the competence that determine the scope of your own competences. I am learning Welsh at the moment, but my Welsh has not got that far, so I can't help you with that. I can only talk about dragons and parsnips for some reason. I'm not quite sure why Duolingo likes parsnips and dragons so much, but this does seem to be obsessed with them. But what we're thinking about is this idea of who tells us that Parliament is sovereign, who tells us that acts of Parliament are the most important source of law in the land. And that's what I mean by this distinction between primary and secondary rules. Okay, so I want to try and explain this a little bit further by looking at a couple of cases. And the first case I want us to think about is the case of Alistair. So Alistair is a case that concerned a conflict between the Acts of Union 1800 between the UK and Ireland and provisions of the Northern Ireland Protocol. So in particular, the Acts of Union stated there should be equal treatment between the people of Ireland and the UK with regard to trade. If you know anything about the Northern Ireland Protocol, you'll understand that that's not quite how it happens. So there are different rules regulating goods that go from England, Scotland and Wales to Northern Ireland than there are for the rules that relate to goods that cross between England and Wales and Scotland. Scotland's also there as well. I'm terrible at forgetting things. Sorry, Aileen. So we have this difference in the different rules of trade going on. So the question that arose, does this mean that there is a contradiction between the Northern Ireland Protocol and the Acts of Union? And this went up to the Supreme Court, and the Supreme Court gave us a very straightforward answer. And they said, nah, there might be a conflict, but it doesn't matter. And the reason it doesn't matter is because of a particular provision of the section, which has got that up on the slide. So Rebecca's getting really good at this now. She's predicting where I'm going. She's fantastic. And this sets out the answer to this particular conundrum, and it's section 7A3, which tells us that every enactment, including enactment contained in this Act, is to be read and has effect subject to subsection 2. What's subsection 2? Subsection 2 is the provision that brings into force all the elements of the Northern Ireland Protocol into domestic law. So in other words, every enactment has to be read and have effect subject to the Northern Ireland Protocol. So if there is a conflict, we know what the answer is. We know what the answer is because Parliament has told us in a piece of legislation, and so it's obvious what we need to do. We just go away and read this particular piece of legislation. Now, this didn't necessarily go down very well with a lot of constitutional commentators who thought, hang on a minute, isn't the Act of Union a constitutional statute? And if it is a constitutional statute, what's going on? Why didn't you not discuss constitutional statutes? To which the simple answer is, well, do we need to, in some senses? Because this piece of legislation has told you what to do if you have a particular conflict in these particular situation. What are the courts doing here? What do I think it tells us about whether the UK is sovereign, but on whether it has parliamentary legislative supremacy? I think what you have here is Parliament giving effect to a piece of legislation, the courts going away and interpreting that particular piece of legislation, and in doing so, they're upholding parliamentary legislative supremacy. There's no need for the court to worry about what's going on with constitutional statutes. The Supreme Court said that the 2018 Act might have modified, but it didn't repeal the Acts of Union. Parliament has given us an instruction. We go away and read this particular instruction. It tells us that we have to go away and give effect to the Northern Ireland Protocol, to the Act of Union, in line with and subject to the provisions of the Northern Ireland Protocol. Nothing's happened in this case to parliamentary legislative supremacy. Nothing has happened to anything to bind its successors. They will hang on, surely something has happened to bind its successors. Well, not really. And this is because of these problems of secondary rules. Because this is what Section 7A is doing. Section 7A is not telling us something about the content of a law. It's given an instruction to the court as to how to give effect to other laws. It's not a primary rule, it's a rule about a rule. But what if you had another rule that came on later on that gave a different, contradictory instruction to courts as to how you're meant to read and give effect to legislation, and you couldn't do both? One of you'd lead to different conclusions because they're expecting you to read and give effect to legislation in different ways. That's when you'd have to start thinking about implied repeal. So there's odd elements of secondary rules going on, the rules about rules. But I also think what this case shows is there's odd things going on when we're thinking about these rules and thinking about these situations. Because in these particular instances, courts aren't just looking at legislation and trying to work out what Parliament meant. I think courts are also doing this against a background of constitutional principles and doing it as part of their role in shared sovereignty to understand what these secondary rules are and what parliamentary sovereignty means in these particular circumstances. And to try and show that, I want to think about Privacy International. So for those of you who aren't used to Privacy International contains everyone's favorite thing, an ouster clause. So an ouster clause is a clause that purports to remove judicial review over a particular act. So in this instance, it was purporting to remove judicial review over decisions of the Investigatory Powers Tribunal. And this was a very cleverly worded provision. So if you look at the wording of the provision, it doesn't just tell you that determinations can't be questioned in any court. That's what happened in Anna's Minnick. And the court looked at that and said, but I know it says determinations can't be questioned, but we can ask ourselves, is this a determination? And if you've made a certain type of legal error that's a jurisdictional error, then you haven't made a determination at all. You thought you had, but you hadn't. You made a jurisdictional error. And that jurisdictional error means that this is void. It never took place. There was no determination. So I'm not questioning a determination. I'm just telling you what wasn't made. So then you get this provision that says, yes, but I'm removing judicial review not just over decisions and determinations, but also, as it lovingly says in brackets, including decisions as to whether you had jurisdiction. I think, clever. Because obviously that's meant to get around how things were interpreted in Anna's Minnick. And that's not what happened. So if you look at a majority, 4 judges to 3 said, no, this ouster clause is not going to remove jurisdiction in certain circumstances. Why not? Well, because we have 2 different types of jurisdictional error. You can have a factual jurisdictional error and a legal jurisdictional error. And we'd want really, really clear words to say that we're not allowed to question a legal jurisdictional error, because then you might be undermining the rule of law. But if it's a factual jurisdictional error, then there's not the same kind of problem. So surely what they must have meant here was we can't question factual jurisdictional errors, but it's okay for legal jurisdictional errors because they haven't made it clear that they meant to include legal jurisdictional errors as well as factual ones. Okay. Now, what I want to draw your attention to is not just this way of the outcome, but how Lord Carnwath decided to determine this. So hopefully, on my next slide, I have a quote from Lord Carnwath. And Lord Carnwath decided this case differently from Lord Lloyd Jones, who was gave the other main judgment in the case for the majority. Lord Lloyd Jones was really just looking at this idea of, can it be legal? Can it be factual? Can I distinguish it in some way? Was there a clear intention? Lord Carnwath was saying something deeper. And Lord Carnwath was looking at this idea of it's not just thinking about the intention of Parliament against a particular backdrop, but I'm also going to be thinking carefully about principles of the rule of law. And I'm constantly going to be thinking as a court about a balance between the rule of law and between the intention of Parliament as set out in parliamentary sovereignty. I think Lord Carnwath is doing something slightly different here. He's not just thinking about interpreting legislation, he's also thinking about how we determine these particular powers of the court when we're trying to think about how we determine these more fundamental rules. So I think what we've got here is what I like to call a form of bipolar sovereignty. And I think what we see in these particular situations is the court is not just thinking about what is Parliament's intention in these circumstances, it's also thinking about background constitutional principles. The courts play a role in accepting legislation in these different types of cases. And it's this way that I don't think Parliament is fully sovereign. I don't think Parliament alone determines the content of things like parliamentary sovereignty or the rule of law. I think this is determined through this element of interactions between Parliament and the courts. And I think when we're determining these questions, courts are doing something slightly different. They're not just thinking about what did Parliament mean. They're also drawing on background constitutional principles. And I'd like to say not only do courts do this, but I think courts should do this. And hopefully that will bring me to some arguments that I want to draw out. So what I'm hoping you can see through this little diagram is my understanding of what I mean by sovereignty being shared, this understanding of bipolar sovereignty, that Parliament and the courts work together to agree and accept certain rules. They come together, not just them, it's a bit more complicated than that, but I'm just sticking with this bit at the moment, to think about they work together to determine these rules, including things like what is the content of legislative supremacy. Why do I think Parliament shouldn't be sovereign in this sense? Well, partly because two heads are better than one, but it's also because I think these fundamental constitutional rules, what I call foundational constitutional rules, are different. And I want to explain a little bit about why I think they're different and why I think Parliament and the court should play a role in determining them. So they're not easy things to define. What I mean by foundational is that they're things that underpin the way in which our constitution works in the UK. So that's all I mean. It's not necessarily saying they're more important in the sense of they're better values, but it's just recognizing their grounding, they're the foundations on which we're building the UK's constitution. So when we talk about the rule of law, parliamentary sovereignty, I see this as foundational. So it's a little bit like thinking about constitutional in the sense of Lord Justice laws when he's thinking about Thoburn and thinking about a constitutional statute, but it's not just thinking about how legislation regulates interrelations between different governmental bodies or between the state and individuals. It's about thinking about the building blocks that tell us what these institutions are, what their powers are, how they can operate, how they work. The kind of, and the basic sort of principles. I'm calling them rules, though I sometimes think maybe they're principles rather than rules, because I think they are things that are recognized by the courts and enforced by the courts through their adoption and infiltration into the common law. So they're a little bit like principles, because their values, they reflect our values, have different weight, but they're also like rules because the courts will pick them up, use these background principles and become part of our rules when they're adopted by the common law. So a little bit like conventions. Conventions can't be enforced in and of themselves, but they might influence the development of the common law. I would say the same as to why foundational constitutional rules are rules and not just principles. Why is it that I think Parliament should not be making these rules by themselves? This is where my phone's switched down, so I might see what the next slide looks like and see if I moved on. Yeah. So why Parliament? Why do I think Parliament is not good enough on its own? I think the ordinary legislative procedure shouldn't just be used for these foundational constitutional rules. I think something more needs to be needed. And a lot of that is influenced by the factors that Professor Meg Russell discussed in her lecture last year. I'm not necessarily sure we should just be using an ordinary lawmaking procedure to make these foundational constitutional rules. I'm also concerned that Parliament is very good at short-termism. We've been talking about this idea of the electorate, civil disobedience, of internal and external limits. We've seen these political limits as being a good thing. But it means you're always thinking in the short term. You're not necessarily thinking in the long term, whereas foundational constitutional rules need to be more long term, not necessarily just short term reactions. Other elements of the UK Parliament is very adversarial. It's very good at having a government and an opposition. It's very good about debating. Not just about debates, more constructive work is done through building a consensus in committees and through work that's done internally to political parties. But its job isn't necessarily there to come up with a consensus of these particular foundational constitutional rules. That's my fourth point. It's about interest balancing. It's about thinking about the different interests of those people you're representing. It isn't necessarily about taking a step back and thinking about these particular principles. My thought is some of these deficiencies can be remedied to a certain extent because of the way courts reason, and courts reason differently. So yes, I'm not saying that courts have a different lawmaking procedure, but I am drawing on the fact that courts do tend to think more in terms of the long term. They look back to long-standing principles as they develop the common law. They go and identify what they might mean. They don't tend to be fully adversarial. Yes, you've got someone arguing one side and someone arguing the other, but when you're determining a particular judgment, you're drawing on those arguments. You're not necessarily just thinking about in terms of adversarial principles. You're also thinking about developing background constitutional principles to then help you resolve a particular partisan debate, kind of argument between the parties in the courts. They're not just about interest balancing. They're also about trying to draw on long-standing legal principles. So my thought is that if you have courts and Parliament working together, that is going to give us a better content of these foundational constitutional rules than if it's just Parliament alone as the sovereign that is telling us what these particular constitutional rules are. Hopefully on my next slide, I'm a lawyer, so I'm going to caveat this a few times. I'm not necessarily saying this is the most ideal form of constitutionalism ever. I'm not talking about should we or should we not have a written constitution that is entrenched and that overrides anything else. I'm looking at something different. I'm trying to think about, can I justify and understand, or what's the best way of thinking about why we have the constitution that we have in the UK? So I'm not necessarily thinking about it in a different way. I also think there are some elements that you will need for this to work. So you need a good functioning democratic and judicial institutions, a bit like Waldron's assumptions that he makes in his theories. But for me, that also means you need freedom of expression, you need proper protection of voting rights, because democracy has to work effectively. I also think when it comes to thinking about a proper judiciary, you need independence of the judiciary, and you need to make sure the legal system is fully functional and funded, and that those people who need to can access it. So all those elements need to be there in order for this to work. And I'm not saying in an ideal world, but there needs to be at least a minimum level of protection. We can argue about how far that goes. But I also think this theory rests on another assumption as well. And this is this assumption that these foundational constitutional rules are what I call essentially contestable. So they're not just contestable, it's It's not just reasonable to disagree about them, but part of the debate is enhanced through this. So the more you talk about these principles, the more we are able to refine them, understand them, and hopefully understand how they operate. So it's not just that we will disagree, but that disagreement helps us to refine what they mean in these particular circumstances. I think that these are based on, our foundational constitutional rules are based on things like democracy, liberty, rule of law. These are all contestable. They need to be debated and they're refined through debate. So hopefully I've persuaded you maybe slightly why it is that I don't think Parliament is or should be sovereign, but it does need legislative supremacy. Why does it need legislative supremacy? Because if it can bind its successors, it starts being the one institution that then tells you what one aspect of foundational constitutional rules are. And I don't want that to be part of my system. There needs to be parliamentary legislative supremacy, so one Parliament can't bind its successors, so that we can still have this element of balance between the different institutions. So it just remains for me to thank everyone for inviting me, and I hope I haven't disappointed you too greatly, and I look forward to hearing your questions. Thank you very much.
So much for coming. Kat, thank you ever so much for the support you've given us for this evening. And Rebecca, thank you as well. Thank you all for coming, and a huge thanks, of course, to Alison once again with a show of hands for our appreciation.